Good afternoon, everyone. My name is Lluc Cerda. I'm coming in from Calgary, Alberta, this afternoon, a Monday afternoon. We're here to talk about your employment rights, your employment Q&A. So feel free to put in your questions in the chat. If you have any questions related to employment law, to termination, severance, anything like that, I'm here for the next half hour to answer those questions. We have Monkey Man who came in first and wanted to announce that. Hi, Tweeter and the Monkey Man. Nice of you to join us. If you or anyone else have any questions about your employment rights, feel free to put those in the chat. We'll be happy to address them. So as you Albertans out there know, this past week was Stampede Week. It's an occasion where a lot of companies, a lot of firms have special events related to Stampede, for a party, for a dinner, what have you. So a Stampede Week party is kind of like a Christmas week party. It's one of those situations where, there could be a lot of alcohol, a lot of camaraderie. The rules of the workplace relating to health and safety, especially considering, harassment and violence in the workplace, continue to apply. We always see this towards the end of the year at Christmas, but likely there would be similar occasions to be cautious at a Stampede party. Same thing. I mean, basically, the right to be free from harassment at work applies beyond the workplace into office parties and all of that. And so, any of you out there who have had a bad experience or feel that someone kind of went over the line at a work party, you don't have to live through that in silence. You can contact us. We can help you in those processes. The Ministry of Labor is the ministry responsible for ensuring that all workplaces in Alberta are free from harassment. I don't want to be a buzzkill, but unfortunately, I know there are probably some people out there today that are going through that, and I do want to extend an offer of help if ever anyone needs anything like that. Now, we have a question here from JR. What constitutes libel or hearsay after dismissal or firing? So libel and hearsay, JR, two completely different things. So libel is a form of defamation, basically, and defamation is when an untrue statement is made that damages your reputation. It's not very hard to imagine what kind of untrue statements we're referring to. If any of you watched the Amber Heard and Johnny Depp trial, those were defamation lawsuits, all right? So each side was saying that what the other had said had somehow defamed them. So that's defamation. It can happen after you're terminated. One instance where it's come up, actually, you're terminated. The employer doesn't tell you you're terminated for cause. They tell you you're just terminated. Go look for another job. You apply for another job. You get an offer. They check your references. They call your former employer. What happens? The former employer basically tells them the worst things about you, right? And they're all lies. So if that happens, that could be defamation. That could have cost you the job. And so then you would have a recourse in defamation against your former employer, on top of potentially a recourse, a lawsuit against them for severance. Now, hearsay doesn't deal with defamatory statements at all. Hearsay, so essentially what it means is, say, JR, that you told me that you took the bus yesterday to go downtown, all right? And then I get called in court to testify, and I tell the judge, well, I know JR went downtown by bus yesterday. Well, that's actually, I'm not allowed to say that because I know it only because you told me. I didn't actually witness you take the bus downtown. So all I can testify to is that you told me that you took the bus downtown. I can't testify to whether or not you actually did. And so that's what hearsay means, is basically you can't testify to things you didn't yourself witness by having somebody else tell you that it happened. That's not allowed in court. So that's a rule of evidence. It's got nothing to do whether or not the statement is defamatory or anything like that. So I have a question here from Keith Smith. Keith asks, can I recover attorney fees in arbitration cases? So the general rule is that you can recover a portion, not the totality, but a portion of your arbitration, of your legal fees, if you're successful at a trial. All right. So you go to trial, you win the trial, the judge will order that you're paid your severance, for instance, as well as a portion of your legal fees. And it's usually between 60 and 80%. An arbitration case, so arbitration is when you hire basically a private judge, someone that both parties agree will decide the matter, but it's not in the context of the court system. And generally, the settlement is going to be private. The general default rule is that, yes, costs should be payable, but at the same time, the parties can agree to whatever they want. There are, for instance, some areas where it's unlikely that you would get costs. For instance, if it's something at the Human Rights Tribunal, you might not get your legal costs. If it's something through the Ministry of Labor, you might not get your legal costs either. If it's in court, generally there's costs. Again, it's up to the discretion of the judge, but in the vast majority of cases, you'll get a portion of your legal costs paid for. Arbitration can mean several different things. For instance, you see a lot of arbitration in unionized contexts. So, of course, we've said this before on the show a lot. We can't help people that are unionized. You have to go through your union. Your union should be the one hiring the lawyer to represent you. So there should be no costs to you, theoretically, but you should check with your union representative about that. And then any costs will be between the union and the employer, whether there'll be a payment of costs or not. We have a question here from Kaylee. Kaylee asks, I've been put on a temporary layoff. Business has slowed down. How's my return date? What are my options? So Kaylee, your options kind of depend a little bit on which province you're in, but generally, if it's the first time that you've been laid off, if you've never been laid off in the past, you can treat your layoff as a termination, and you can go after your severance. So a lot of people think that an employer can lay them off. That's actually not correct, all right? Unless you've consented to the layoff, then you can tell your employer, I'm not accepting this. I'm not accepting that you can not provide me with work and pay for several weeks, if not months in the future. I have more pay like everyone else. I need a job, right? If you're not going to provide me with work, then provide me another job, right? So generally, if it's the first time you've been laid off, you can go after your severance, all right? So if you are looking to get more details about how much severance you're entitled to, we actually have made it as simple as we can for you. We've created a website where if you answer 4 quick questions, we'll tell you what we think your severance entitlements are going to be. That website is called pocketemploymentlawyer.ca. And it's not like we're asking you for your SIN card either. I mean, we just want service, what kind of job you did, and how much you earned. And we don't even need you to attach an email or anything like that. It's all very confidential. So you can go on there, see what your severance entitlements likely are. If you want to speak with us thereafter, you can very easily make an appointment to speak to one of the lawyers at the firm, including me. And we'll be happy to discuss what your options are. All right. Now, there are a few exceptions to what I just said that a layoff basically entitles you to severance pay. One of those exceptions, as I was mentioning, is if you've been laid off before, have been recalled, and did go back and start working again, then the law will imply into your employment relationship the right for the employer to lay you off. So it's very important, if it's the first time you've been laid off, to really think about it, all right? To really think about whether you want to go back to a place that can now lay you off at will anytime in the future. The other exception is if you've signed an employment contract. So this is where you have to dig up that document that you looked at once 10 years ago, haven't looked at again, and see if there's a clause in there that allows the employer to lay you off. If you sign that agreement, then that's legal, and now you've given them the right to lay you off. That said, even if your employer has the right to lay you off because of past practices or because of the fact that there's something in your contract that allows it, an employer cannot lay you off forever. All right. So the length of time they can lay you off depends from province to province. In Ontario, they can lay you off at up to 35 weeks, which is 8 months, if they continue your benefits. All right. If they don't continue your benefits, they can only lay you off for 13 weeks. If you're in Alberta, then it's a maximum of 60 days, right? They can lay you off for a maximum of 60 days in a 13-month period, in a 120-day period, sorry. So after that, what happens? Well, what happens after that is you've been terminated. You're owed severance. If they haven't called you back in time, you're owed severance. And so if you've been laid off more than 13 or 35 weeks in Ontario or more than 60 days in Alberta, reach out to us. We'll help you get your severance package so that you can have something to cushion the blow. Because if you've already been waiting all that time without compensation, we can help you get some money to tide you over until you find a new job. So you can reach out to us. We're at employmentlawyer.ca. We have a lot of information about what we've been discussing today on our website. You can also access the Pocket Employment Lawyer from there. I'm sorry, and see what your severance entitlements might be across 3 provinces. That's BC, Alberta, and Ontario, and find out what it is that your employer can and cannot do. So basically, a lot of employers and sometimes employees think that their employer can do just about anything. To you, change your hours, change your compensation, do any of that. That's not the case. All right. That said, we had an interesting decision from the Court of Appeal come down in Alberta last week that I do want to tell my viewers about. So in that case, amongst other things, what had happened is at the start of the pandemic, the employer had reduced the employee's salary. So if you've watched this show before, you know that if your employer reduces your salary, you can treat that as a constructive dismissal, right? So the reason you work for that employer is, amongst other things, that they guaranteed you a certain amount of salary. Okay. Now, if they change that, if they reduce the salary, and if it's a big reduction, I would say 12 to 15% or more, that's a constructive dismissal. That entitles you to say, you know what, I'm quitting, and I am going to, but because you forced me to quit by changing my salary, you owe me severance. Okay. So we had a decision come in last couple of weeks ago from the Court of Appeal that said that's true, that's still true, but you have to quit very quickly. So you have to let your employer know within, which is basically 2 weeks, all right, that you're not accepting the job. What that means, and what I think I'm trying to drive home to you, if you're watching here today, is if your employer is changing any aspect of your job, all right, as soon as you know, reach out to us, schedule an appointment so we can talk to you, let you know what your rights are. Your decision will be your decision in the end, but we want you to know what your options are, because unfortunately, if you wait too long, a judge will say, well, listen, you were okay with that changed salary for 10 days, therefore you're stuck with it. You've accepted the change. That case might be appealed to the Supreme Court of Canada, and hopefully that rule will change. But it's the rule we're stuck with right now. So it's the one that we have to work with now. If the employer is changing any aspect of your working conditions, anything like that, reach out to us sooner rather than later to protect your legal rights. All right. So that's an important decision came last week or the week prior. So I just want everyone to be aware of that. So we have another question come in from Brian. Brian is asking, can your boss withhold a bonus payment as you were fired before it was handed out? All right. So the general rule is this, Brian. When you're terminated, you're owed an amount of severance, and it's usually expressed in months. So imagine you get terminated in July, we're in July, you get terminated in July, the bonus gets paid in December, right? And you're entitled to 6 months of severance. So that should take you from July to January, all right? So basically what that means is anything you would have earned from July to January, the employer has to pay to you, all right? And because the bonus was going to be paid in December, which is within that 6-month period, then you are entitled to the bonus, all right? So absolutely, even though you're terminated, doesn't mean that you forfeit the bonus, forfeit any other aspect of your compensation. When we tell employers that we want, for instance, 6 months of severance for our clients, we want all the compensation they would have gotten. So it's not just base salary, it's base salary, it's benefits, it's pension contributions, it's car allowances, it's bonus plans, of course, it's RSP matching, all of it. Whatever it is that you're getting in exchange for your labor, you continue to be allowed to get during the severance pay period. All right. So all of that is part of what the employer owes you. So if during that severance period you would have gotten a bonus, now mind you, I'm not talking about just like some Christmas bonus, a turkey or a couple $100, a performance-based bonus, right? And I'm not saying it's got to be your performance. It can be the company's performance. If there's some sort of profit sharing, whatever, you get a slice of that pie. You're entitled to that slice of the pie for if it was meant to be paid out during the severance period. And I say we're not going to go for 6 months of. Well, the last time you got a bonus was in December 2021. You were working towards the bonus all of July, all the way up until July, and then your severance runs until January. So we're going after a full year's bonus that you'd be owed by the time December rolls around. So definitely, yes, you are entitled to your bonus even though you've been terminated. Oh, my name is Lluc Cerda. I'm managing at the Calgary office of Samfiru, Tumarkin. I'm here to take any questions you have today about employment rights that you have, whether it's in the things that are related to your termination or what happens in the in the workplace, human rights, anything like that. Feel free to reach out to us, and we'll be happy to discuss that with you. One thing I wanted to talk a little bit about today that I've been dealing with recently is the concept of the duty to inquire. All right, so it comes up most often in situations of when someone has, for instance, a mental health disability or an addiction issue at work. So both of those situations are classified by the Human Rights Tribunal, by the Human Rights Code, as disabilities. All right, and because of that, both of those situations need to be accommodated. Now, the nature of both a mental health disability and an addiction are that the people who are suffering from those disabilities have very little insight into the fact that they might be suffering from a disability. The ability to tell their employer, well, listen, I'm behaving this way because I have a disability, I need an accommodation. So you can imagine if you have a disability like that, you might miss work, you might be on substances at work or things like that, which could be very dangerous and may result in you getting some sort of discipline, potentially even a termination. What's important to remember is before the employer terminates you or even issues you any form of discipline related to a mental health issue or an addiction issue, the first step the employer has to do is determine whether you have a disability, and if you do, whether it can be accommodated in the workplace. So even though you didn't tell your employer, listen, I have a disability, I need to be accommodated, there are certain times where the employer has to inquire. They have a duty to inquire as to whether you have a disability or not. So imagine, we see it a lot here in Alberta, for instance. Sometimes someone will have some alcohol or some cannabis in their bloodstream, might be operating a forklift or something, gets into an accident, and the employer, as part of the investigation, will do a drug test. right? And the drug test comes back positive. So in a lot of cases, that could lead to a termination for cause with no severance, right? What's important is that you speak to us and also speak to your doctor once that happens to see if the reason why those drugs in your bloodstream is related to an addiction. All right. If it is related to an addiction and the employer failed to inquire as to whether you had an addiction, it could be that the employer is liable to you for, of course, your severance, but also human rights damages. You might be reinstated into your job. I mean, these are tricky, situations for anyone to live through, but definitely realize that there is help out there. So that kind of thing is happening to you. We're happy to help. And when you speak to us, you can rest assured you're speaking to a lawyer. So the concept of lawyer-client privilege applies. Everything you tell us is confidential. And we try to create a safe space so you can speak, earnestly about what's been happening. And that applies, of course, when you're talking about your health issues or your addiction issues, but in any aspect of your job. As I was talking about earlier, there can be harassment in the workplace. It can be very difficult to speak out about, and we're trained to listen, to tell you what your legal rights are, but also try to provide a measure of comfort that there is a light at the end of the tunnel, if you will, if you're living in a possible situation at work. All right. So another question that we have coming in here today is from Lorraine. After decades with my company, my employer is implementing a contract for all employees. So am I obligated to sign it? So that's an interesting question. So the thing about employment contracts, you have to be very leery of them. I always tell, I get calls all the time from employees. They just been hired. They were promised an employment contract. The employer is dragging their feet in providing the employment contract. And the employee is getting a bit anxious about it. They want the contract. They want to sign it. They think the job is more official once there's a contract. First thing I always tell them, listen, the contract is there to benefit the employer, right? The employer wrote it. The employer wrote it for their benefit, all right? Even if there is no employment contract, no written employment contract, in the eyes of the law, the fact that you're going to work and you're getting paid to go to work implies that there's an unwritten contract, all right? So contracts don't have to be written down in the eyes of the law. You can have a verbal contract, you have an unwritten contract, and those contracts can be enforceable. And in fact, the vast majority of employees who don't have employment contracts have enforceable terms of employment that they can have a judge enforce, all right? So when clients come to me and say, well, I've been here for 10 years, all of a sudden they want me to sign this contract. What should I do? Well, firstly, I'll look at the contract, of course, but invariably what I see is that the employer is reserving for itself a lot of rights that it didn't have prior to presenting this contract. So the most important, of course, is they're trying to limit how much severance you get when you're terminated. So the thing to remember, and the other thing that worries a lot of my clients, is if I don't sign this, I'm going to be out of a job, all right? That's not the case, all right? If you don't sign it and they decide to terminate you, they'll still owe you severance. So if you've been there somewhere 10 years, you're looking probably at upwards of 9 to 10 months of severance that you're owed, right? If you sign the contract, that 10 months could become as little as, okay? So just multiply that by your yearly salary, and you see that the fact that they would have to pay you 10 months rather than 8 weeks is a reason why they won't terminate you, right? Because they'll have to pay you more. I've seen it happen that you sign the contract and 3 weeks later, like, okay, here's the door and here's your 8 weeks and we're done with you, right? Because they wanted to terminate you the day they presented you with the contract. Okay, so be wary about that. You have entitlements, and those entitlements to severance are more than just a lump of money that you get when you are terminated. They are one of the reasons why you haven't been terminated yet. So you don't want to give those up, right? You want to make sure that that protection stays in place. That gives you job security, and it gives you a cushion if you are terminated while you look for a new job. All right. So definitely watch out if you see an employment contract. It's worth reaching out to us, having that reviewed, understanding what your rights are. Okay. Generally, you are not required to sign the contract, especially not if it's only to keep your job. All right. Keeping your job, they can't. And I hear a lot is this as well. They'll tell you signing the contract, but we're going to take that to mean, well, that's not quitting at all in the eyes of the law. Have agreed to continue to work for them. Nothing's changed on your end. You just don't want to sign the contract. So you're ready and willing to work. If they decide to terminate you, then that's their decision. Unfortunately, the employer is basically allowed to terminate you for business reasons. If there's lack of work, or even if they want to go in another direction, or even if they want to insist that everyone has to have this contract, they can terminate you for that. But they have to provide you with severance. All right. Very important to keep that in mind. So that's basically what I do want to drive home to as many of you as possible today, is that these contracts are precisely that. You have something to say in this contract. You have a right to have input into a contract, especially if you've already been working with them with your employer for a substantial amount of time. So don't take it like you have no choice but to sign, especially if you haven't had it reviewed by a lawyer. Reach out to us. We're happy to discuss that with you, review it with you, make sure you understand what you're signing, so that you have a contract that benefits you and is a fair deal, essentially, because you're going to work for these people for many more years. You want to make sure that you're getting a fair deal out of the exchange, right? So keep that in mind. All right, my name was Lluc Cerda. Well, it still is. My name is Lluc Cerda. I'm associate here at Samfiru Tumarkin. I'm the managing associate of our Calgary office, serving the great province of Alberta. Feel free to reach out to me or to any one of my staff, questions about the employment law in Alberta. Otherwise, we're always happy to speak to you if you're in BC or Ontario as well. We have lawyers there ready and willing to help you with your employment law questions. We have another show just like this tomorrow. You see it on your screen there at 3 p.m. Eastern Time. Feel free to join if there's any questions I haven't been able to get to today. And we will be happy to answer your questions coast to coast, BC, Ontario, Alberta. We're happy to help. My name is Lluc Cerda once again. Thanks for joining, and I hope you have a great rest of the day.